Hey everyone, and welcome to This Explainer. Today we're diving into the illusion of proof, science, memory, and the ultimate safeguard. We all kind of grow up believing that when that gavel bangs, right, the truth has been undeniably proven. It's case closed. But as we unpack the data today together, we're going to find some deeply unsettling cracks in that whole foundation. So I want you to think about this for a second. What if the evidence we trust the absolute most is exactly what puts innocent people in prison? I mean, it creates this immediate cognitive dissonance, doesn't it? We're so culturally conditioned to believe that courtroom evidence, especially the scientific stuff or a confident eyewitness, is basically infallible. We've all seen those procedural TV shows, right? The ones where the case is neatly wrapped up in under an hour just because they found a fingerprint or got a witness to point a finger. But the reality? Well, it's a whole lot messier. The deeply uncomfortable truth we really have to face today is that a failure of method literally equals a failure of justice. Let's take a quick mental inventory of what we usually consider the gold standards of criminal investigation. We're talking about things like the Reid interrogation technique, fingerprint analysis, firearms and toolmarks, hair and fiber analysis, blood spatter, even handwriting analysis. For decades, these have been widely assumed to be, well, perfectly dependable for testing an allegation. But here's the kicker. The research actually shows they've produced not just wrong evaluations, but actual wrongful convictions. A lot of these forensic fields suffer from poor standardization, real error rates, and highly subjective interpretation. So the absolutely crucial point to take away here is that perceived scientific reliability is absolutely not the same thing as actual reliability.
And those flaws don't just stop at the lab door. They actually extend right into our own minds. Eyewitness misidentification is, incredibly, the leading cause of wrongful convictions that are later overturned by DNA evidence. Just think about that for a second. Faulty memory combined with misidentification is incredibly dangerous. The Innocence Project has shown us that the single most common thread in DNA exonerations is a totally confident witness who was simply wrong. See, we like to think of human memory as a video recording on our phone that we can just play back on demand, but it's not. Memory is reconstructive. It gets shaped after the event by suggestion, by feedback, and honestly, just by the simple passage of time.
To really grasp the devastating human cost of this, we need to look at the heartbreaking case of Jennifer Thompson and Ronald Cotton. Back in 1984, Ronald Cotton was identified by the victim of a horrific assault, and he was convicted. The victim was absolutely certain he was the man. Absolutely sure. But jump forward to 1994, DNA technology has finally advanced enough, and Cotton's new lawyers request testing of the preserved evidence. By 1995, those results come back, and Cotton's DNA does not match. The samples actually matched a completely different man, Bobby Poole. Finally, Cotton's innocence was established, and he was exonerated. But guys, he lost 11 years of his life to a mistaken eyewitness identification. 11 whole years.
So how in the world does this happen? Why do honest, totally well-meaning witnesses make such catastrophic mistakes? Well, the psychology usually boils down to three main factors. First up is brief exposure. Often, a witness only gets a fleeting glimpse of the perpetrator, usually in really poor lighting, and almost always while under immense, terrifying stress. Second is stranger identification. It is just incredibly difficult for the human brain to accurately recall the face of someone we have absolutely no prior familiarity with. And third, and this is perhaps the most insidious one, is suggestion and feedback. You see, a witness's confidence doesn't necessarily come from the event itself. Their confidence actually skyrockets after the event, based on external feedback, police reinforcement, or just the passage of time.
Now, because the legal system knows that the malleability of the human mind is this massive, life-altering vulnerability, there are actually mechanisms built in specifically to catch these kinds of errors. And that brings us to the Turnbull Guidelines. This is a crucial rule that dictates a judge's absolute duty to warn. Basically, a judge has to make the fact finder, which is usually the jury, acutely aware of the specific shortcomings and weaknesses that can cause even a completely honest witness to make a mistake. This mandatory warning has to happen before any conviction can rest purely on an identification. It's essentially a vital safety net to stop a simple human error from completely destroying an innocent life. But honestly, we can't just rely on warnings in the courtroom, right? We have to fundamentally reform how the evidence is gathered in the very first place. A proper police identification lineup needs to be conducted almost like a rigorous scientific experiment to curb any bias. It starts with double-blind administration. This means the officer running the lineup must not know who the suspect actually is, and the witness has to be explicitly told exactly that. Then you need proper composition, meaning the fillers have to reasonably resemble the suspect's description so the actual suspect doesn't just stick out like a sore thumb. Add in a clear, no-pressure instruction that the perpetrator may or may not even be in the lineup, taking away the pressure to just pick somebody. After that, you immediately record the witness's confidence level right then and there, before any feedback can inflate it. And finally, sequential presentation. Showing subjects one at a time prevents the witness from just comparing faces and picking the best match out of a lineup.
Now, you might be sitting there thinking, okay, sure, human memory is flawed, but hey, that's exactly why we have objective forensic science, right? Well, not quite. Even so-called objective evidence has to be interpreted by human beings. And humans, well, we suffer from observer bias, expectancy effects, and motivated reasoning. This is what experts call forensic confirmation bias. It's what happens when the judgment of a forensic examiner is driven by their own expectations, prior beliefs, or the context of the case, rather than just the raw evidence itself. Without even realizing it, they inadvertently manufacture false corroboration.
Let's break down exactly what creates that bias, like what contextual information actually warps an expert's perception in the real world. Well, it can be the lurid emotional details of the crime itself. It could be knowing the police theories or hearing about prior eyewitness IDs. It can be prosecutorial expectations, and honestly, it is very often the immense pressure from investigators during those big, high-profile cases. When an examiner is sitting in a lab and gets told, hey, we already have a confession, we just need you to confirm this fingerprint, their brain is literally primed to see a match, even if the actual data is completely ambiguous. Now, if you find it a little hard to believe that highly trained, seasoned experts could be swayed like this, you really need to consider the shocking case of Brandon Mayfield. Mayfield was an Oregon lawyer arrested by the FBI back in 2004 in connection with the horrific Madrid train bombings, which tragically killed 191 people. So Spanish police had recovered a partial fingerprint from a bag of detonators. The FBI ran that print through their massive database and declared a 100% match to Mayfield, who, by the way, happened to be a US-born convert to Islam. He was held for about 2 weeks as a material witness, and the government used heavy surveillance powers against him. There was really only one tiny problem. It wasn't his print. No way.
Let's look at the anatomy of this massive error because it completely, entirely punctures the myth that latent print identification is some exact error-free science. Get this, 3 distinct FBI examiners plus a totally independent court-appointed expert all confirmed a match that was simply wrong. How does that even happen? Well, a Department of Justice review later found that they engaged in massive circular reasoning. Once that very first examiner committed to the match, the others essentially just fell in line and confirmed it. Plus, Mayfield's religion and his associations likely reinforced their suspicion instead of triggering the scientific caution that it should have. The real print actually belonged to an Algerian national named Unan Daoud. The entire case against Mayfield collapsed, eventually resulting in a rare formal apology and a cool $2 million government settlement. So, look, this is clearly a systemic problem, which means we desperately need systemic reforms. Courts can no longer just sit back and assume that evidence presented to them is completely independent and objective. We have to actively police how it's generated. First up, we must scrutinize the method, really examining exactly how the forensic conclusion was reached in the first place. Second, investigate contamination. We need to test whether different sources of evidence cross-contaminated one another, like, police theories influencing the scientists. Third, we have to explicitly test for bias by holding reliability hearings before that evidence is ever admitted. And fourth, we need to relentlessly educate judges and juries to make the fact finders truly alive to the reality of confirmation bias. So with all this systemic fragility we've talked about, with human memory being totally reconstructive, with forensic science being subjective and highly prone to bias, what is the actual solution here? What is the failsafe? Well, it is actually the highly misunderstood role of the criminal defense lawyer. This role is the ultimate constitutional safeguard against state power. The defense lawyer is that essential participant who steps in to challenge the methods used to build the allegation and to create the doubt that the prosecution is legally obligated to dispel. We desperately need to reframe the public narrative around this profession. Right now, there is this massive public bias that believes defending an accused person somehow means supporting the crime itself. But that is fundamentally absolutely incorrect. Defending an accused means working within the lines of the legal system to keep the state to its proof and to keep the entire process honest. It means protecting the right to a fair trial, serving as a frontline guardian against miscarriages of justice, and ensuring that no one, and I mean no one, is put in a cage purely based on flawed evidence or an angry public mood. The Supreme Court of India actually articulated this perfectly in a landmark 2010 case. They said,
Every person, however wicked, depraved, vile, or repulsive he may be regarded by society, has a right to be defended in a court of law, and correspondingly, it is the duty of the lawyer to defend him. And this isn't just fancy legal jargon. This right to be defended is a core facet of the rule of law itself. It is the absolute bedrock foundation upon which every single other trial protection we've talked about today is built.
And let's really drive home the stakes here. This isn't just about individual trials. It is quite literally about the survival of democracy itself. A democracy only survives when even the most unpopular accused persons receive proper representation. The accused is always presumed innocent and entitled to a robust defense, regardless of whatever the current public mood dictates. That is exactly why any bar resolutions attempting to refuse a brief to an unpopular defendant are strictly void. Justice rests entirely on evidence and law. It must never, ever rest on public opinion.
Which brings us to our final thought for today. I really want to leave you with this question to ponder the next time you're scrolling and read one of those sensational open and shut headlines. If justice truly rests on evidence, and as we've seen today, the evidence we trust the absolute most is inherently flawed by human memory and systemic bias, who will stand between you and the immense power of the state? The answer is the defense lawyer, standing there insisting that the proof is real, the methods are sound, and the truth is actually the truth. Thank you so much for joining me for this explainer. I really hope it gave you an entirely new lens through which to view our justice system.